The Limited Liability Partnership Act, 2008. Steps to incorporate LLP. Name reservation. The first step to incorporate Limited Liability Partnership, LLP, is reservation of name of LLP. Applicant has to file e-Form 1 for ascertaining availability and reservation of the name of a LLP business. Incorporate LLP. After reserving a name, user has to file e-Form 2 for incorporating a new limited liability partnership, LLP. E-Form 2 contains the details of LLP proposed to be incorporated, partners designated partners details and consent of the partners designated partners to act as partners designated partners. LLP agreement. Execution of LLP agreement is mandatory as per Section 23 of the Act. LLP agreement is required to be filed with the registrar in e-Form 3 within 30 days of incorporation of LLP. Partners and their relations. Eligibility to be partners. Section 22. On the incorporation of LLP, the persons who subscribed their names to the incorporation document shall be its partners, and any other person may become a partner of the LLP by and in accordance with the LLP agreement. Relationship of partners. Section 23. Save as otherwise provided by this Act, the mutual rights and duties of the partners of LLP, and the mutual rights and duties of a LLP and its partners, shall be governed by the LLP agreement between the partners, or between the LLP and its partners. The LLP agreement and any changes, if any, made therein shall be filed with the registrar in such form, manner and accompanied by such fees as may be prescribed. Cessation of partnership interest. Section 24. A person may cease to be a partner of a LLP in accordance with an agreement with the other partners or, in the absence of agreement with the other partners as to cessation of being a partner, by giving a notice in writing of not less than 30 days to the other partners of his intention to resign as partner. The cessation of a partner from the LLP does not by itself discharge the partner from any obligation to the LLP or to the other partners or to any other person which he incurred while being a partner. Registration of changes in partners. Section 25. If the LLP contravenes the provisions of subsection 2, the LLP and every designated partner of the LLP shall be punishable with fine which shall not be less than 2,000 but which may extend to 25,000. If any partner contravenes the provisions of subsection 1, such partner shall be punishable with fine which shall not be less than 2,000 but which may extend to 25,000. Extent and limitation of liability of LLP and partner. Partner as agent. Section 26. Every partner of a LLP is, for the purpose of the business of the LLP, the agent of the LLP, but not of other partners. Extent of liability of LLP, Section 27. The LLP is liable if a partner of a LLP is liable to any person as a result of a wrongful act or omission on his part in the course of the business of the LLP or with its authority. An obligation of the LLP, whether arising in contract or otherwise, shall be solely the obligation of the LLP. Extent of liability of partner, Section 28. A partner is not personally liable, directly or indirectly, for an obligation referred to in subsection 3 of Section 27 solely by reason of being a partner of the LLP. The provisions of subsection 3 of Section 27 and subsection 1 of this section shall not affect the personal liability of a partner for his own wrongful act or omission, but a partner shall not be personally liable for the wrongful act or omission of any other partner of the LLP. Holding out, Section 29, who by words spoken or written or by conduct, represents himself, or knowingly permits himself to be represented to be a partner in a LLP, is liable to any person who has on the faith of any such representation given credit to the LLP, whether the person representing himself or represented to be a partner does or does not know that the representation has reached the person so giving credit. Unlimited liability in case of fraud, Section 30, in the event of an act carried out by a LLP, or any of its partners, with intent to defraud creditors of the LLP or any other person, or for any fraudulent purpose. The liability of the LLP and partners who acted with intent to defraud creditors or for any fraudulent purpose shall be unlimited for all or any of the debts or other liabilities of the LLP. Whistleblowing, Section 31. The court or tribunal may reduce or waive any penalty leviable against any partner or employee of a LLP, if it is satisfied that such partner or employee of a LLP has provided useful information during investigation of such LLP, or when any information given by any partner or employee, whether or not during investigation, leads to LLP or any partner or employee of such LLP being convicted under this Act or any other Act. Financial disclosures. Maintenance of books of account, other records and audit, etc. Section 34. Every LLP shall file within the prescribed time the statement of account and solvency prepared pursuant to subsection 2 with the registrar every year in such form and manner and accompanied by such fees as may be prescribed. The accounts of LLP shall be audited in accordance with such rules as may be prescribed. However, the central government may, by notification in the Official Gazette, exempt any class or classes of LLP from the requirements of this subsection. Annual Return, Section 35. Every LLP shall file an annual return duly authenticated with the registrar within 60 days of closure of its financial year in such form and manner and accompanied by such fee as may be prescribed. Any LLP which fails to comply with the provisions of this section shall be punishable with fine which shall not be less than 25,000 but which may extend to 5 lakhs. Conversion into LLP. Conversion from firm into LLP. Section 55. A firm may convert into a LLP in accordance with the provisions of this chapter and the second schedule. Conversion from private company into LLP. Section 56. A private company may convert into a LLP in accordance with the provisions of this chapter and the third schedule. Conversion from unlisted public company into LLP. Section 57. An unlisted public company may convert into a LLP in accordance with the provisions of this chapter and the fourth schedule. Registration and effect of conversion. Section 58. The registrar, on satisfying that a firm, private company or an unlisted public company, as the case may be, has complied with the provisions of the various schedules, provisions of this Act and the rules made thereunder, register the documents, issue a certificate of registration in such form as the registrar may determine, stating that the LLP is, on and from the date specified in the certificate, registered under this Act.